Welcome back to Case of Interest Kohberger. I'm Newswatch 16 Stacey Lang. We have a lot to talk about this week. I'm sure you know the big headline in the University of Idaho murder case that came out this week, of course, that a grand jury in Idaho has indicted Bryan Kohberger on 4 charges of first-degree murder and a charge of burglary. And we had a lot of viewers reach out to us and say, hey, haven't I heard this before? It sounds like deja vu, because, of course, he was charged with those 4 counts of first-degree murder and burglary back in December here in Pennsylvania, and then was extradited back to Idaho to face those charges. Those charges still exist. What we know, the affidavit that was released by police, that is all still very valid. What needs to happen in any case in any state around the country is that those charges brought by police and prosecutors need some kind of review, be it from a judge through the course of a preliminary hearing or through a grand jury. And it depends state to state how that process works. The system in Idaho is fairly similar to the system here in Pennsylvania. What's a little different is that the grand jury process is very similar to what the federal court process is, where the grand jury operated in secret and handed down this indictment, and that stands as that judicial review, so to speak. So we were preparing for a preliminary hearing on June 26th. We now know that will not happen, which means a lot of things as far as how the prosecution of this case will work, and we're going to get into that. We talked to a legal expert about that. The biggest thing is that we will not learn much more about the evidence against Bryan Kohberger like we were expecting to hear in that preliminary hearing. Let's take a look at the indictment that has been posted on the Idaho court's case of interest page. I'm going to take a look at that now. That document, of course, will include a link on WNEP.com if you want to take a look for yourself. There isn't a whole lot here because the grand jury doesn't have to present an affidavit like police and prosecutors do. They don't have to explain why they reached the conclusion. They don't even have to tell us if it was a unanimous decision. All we know is that there were 16 grand jurors, as is the law in Idaho, and either majority or unanimously voted to hand down this indictment. And here's a list of the charges. And if you scroll onto the next page, it doesn't say much more other than each count of murder is tied to each one of those victims. First, Madison Mogen, Kaylee Gonzalez, Xander Carnadel, and Ethan Chapman. They're all of the counts that he is now facing. And he'll be arraigned in what's known as a formal arraignment on Monday. And we'll talk a little bit about that later as well. The new court documents that came out today actually have to do with that grand jury. The prosecution asked the judge in this case to seal the list of grand jury witnesses. We already know that we can't know what the testimony was in this grand jury. Now we will definitely not know who actually testified, because they filed this motion to seal the grand jury witnesses, and then almost immediately after the judge granted it. But I wanted to read part of the request from the prosecutors for you. The second paragraph here says, in support, the state respectfully represents to the court that it has received numerous complaints from potential or prospective witnesses or their families and associates regarding being harassed both in person and via social media. The reports of harassment have included threats as well as what appears to be intimidation. Given this and the broad publicity surrounding these proceedings, the state respectfully submits that releasing the names of the witnesses who appeared before the grand jury would invite additional harassment, intimidation, and possible threats, and undermine not only the integrity of this case, but the parties' prospective rights to a fair trial with an impartial jury. This has been a narrative since day one on this case, is protecting Bryan Kohberger's right to a fair trial by trying to tamp down any pretrial speculation through media coverage because of the gag order. And now that the grand jury helps them protect and keep close to the vest some of the evidence against him. We discussed that with a legal expert, Brett Regal, an attorney, a defense attorney in Monroe County. So he comes at this very much from the defense perspective, but he explains what the thought of prosecutors might be proceeding into this grand jury route. So let's take a listen to what he had to say.
So we know now that that a grand jury has been working behind the scenes for who knows how long, and this indictment comes out. I think that the average viewer sees this and goes, wait a minute, I thought this already happened. So what's the difference between, the charges that were filed, in December and now this?
Uh, Not a lot of difference, sort of. Really, the way to kind of explain it is that the charges that were filed in December were an accusation made through the police and through the prosecutor. And then, other than simply making sure that the requisite elements are listed out in the paperwork, that doesn't trigger any deadlines for him. It hasn't really been judicially reviewed to determine whether or not there's a level of substance to it. So there's two ways that something goes from those accusations to then being a formal indictment, or in Pennsylvania, we call them an information. And that is either that there's a preliminary hearing and a judge binds the charges over, or there's an indictment from a grand jury. And in fact, Idaho's process looks to follow the federal system a little more closely than it would follow the Pennsylvania system, where if you've got a preliminary hearing scheduled, but a grand jury indictment comes in before it, then the preliminary hearing is taken off the calendar because there's no longer a need for it.
Strategically, from a prosecutor's standpoint, why would you go that grand jury route?
There's an old joke that goes that in a grand jury, the prosecutor ought to be able to get the jury to indict a ham sandwich. And what the joke essentially means is that a grand jury is not a bipartisan proceeding. It's not a both parties get a shot and a say. It is a one-sided process. So if there's good evidence that the prosecution has and then some questionable evidence, they just don't share that part. They only share the part that helps support their case. So in some states, there's a right to participate in the grand jury if you provide notice and things of that nature. In other states, there isn't a right to participate in it. You just have to kind of wait for what comes out of the secret proceedings. And they're generally secret in most, if not all, states. Pennsylvania has both an investigating and indicting grand jury process, and it's supposed to remain entirely behind closed doors until an indictment is pronounced, or in the context of an investigating jury, if they make recommendations to the prosecutor.
Could that the secret element be part of the puzzle here? Because everything we had heard was that this preliminary hearing on June 26th was essentially going to be a mini trial. But now all of the evidence that was presented to the grand jury, the public won't see now, as opposed to what would have happened in the hearing.
That is 100% correct. The public doesn't see it, whether that is an effort to tamp down some of the public interest in the case. It could be whether it is simply from a time and effort perspective more efficient, whether it is a matter that from a perspective of the prosecution not wanting the defendant to have a crack at some of their witnesses. There's a lot of different reasons that the prosecutor can use this tool. And here they obviously chose to use it for one, some, or all of those reasons.
So from someone on the defense side, when you hear this, do you think, there might be some weaknesses in the prosecution's case?
Call me an eternal optimist for the defense. I always think that there are some weaknesses in a prosecution's case somewhere. But that may be it, or it may simply be that from the standpoint of what they were looking at coming out in a preliminary hearing, they felt more comfortable going in front of the grand jury and getting the indictment in that fashion. They still have to turn everything over to the defense through the discovery process. So it's not like the defense won't at some point know what was said by whom, etc. But bear in mind that from the defense standpoint, one of the things that sometimes you're doing with a preliminary hearing is getting a version of events out from the questions you want to ask. And then at the time of trial, when you're asking similar questions, you may seize upon differences in the way that the person answers, or internal conflicts with their story, or even external conflicts with person A says this, person B says that. The only questions that get asked in a grand jury proceeding are the ones that the prosecution wants asked. So there isn't that opportunity for the defense to ask the things that are important to it ahead of time.
And fewer chances to find the inconsistencies in statements.
Right. Yep.
Strategy. Yeah. So we know that Kohberger will be in court on Monday for an arraignment on this indictment. What comes next?
So in the arraignment, that's going to be the spot where the court is giving him all of the internal deadlines to the case as they currently exist. Like, when will you have all of your discovery? When are your pretrial motions due? When is there going to be a status conference or a pretrial conference to determine if it's going to trial, how long, etc. There may be requirements under Idaho's procedure for any offer that the district attorney's office, the prosecutor's office, wants to extend to Mr. Kohberger. Something along the lines of, well, if you plead guilty to one of the homicides and agree that it's life without parole, we won't pursue the others, or things of that nature. And there's no real way to tell that until the judge says, here's the scheduling order. This is what's going to happen, and this is the time frame for it all. And I guess it is important to understand that those time frames are really everyone's best guess, because if the defense is working on an investigation and needs more time, they're going to file a motion, and the court would be, it'd be a very, very unusual day for the court not to grant at least a first request for some additional time, and it wouldn't be unusual to grant several.
Again, that was Brett Riegel from Arm Lawyers in Stroudsburg in Monroe County, where Bryan Kohberger is from, helping us understand what prosecutors in Idaho might be thinking now that this grand jury indictment has come out, and what that could mean for Kohberger's case. Of course, we were expecting that preliminary hearing, which was set to become a, quote, mini trial, as prosecutors had called it. But that's now not going to happen. It does mean Kohberger is going to be in a courtroom much earlier than we anticipated. On Monday, he's scheduled to be arraigned on those charges from the grand jury. We will have coverage of that hearing all day long on Newswatch 16, as well as on WNEP.com. And of course, we'll be breaking it down here. So thanks for tuning in for another episode of Case of Interest Kohberger.